So I want to talk a little bit about two ways of making a difference. That's something that people want to do when they graduate from a law school and become lawyers generally, but also more generally. A lot of idealistic people want to do that. I want to talk about two ways of doing that. The first way is my way. We're going to talk about working within the surveillance state. But the other way is Snowden's way, blowing it up with a series of massive and damaging leaks beginning in 2013. I like to talk about how I entered government in around 2006, left government in 2013. It changed some of my opinions about surveillance along the way, and in that I have that in common with Mr. Snowden. But I left under somewhat different circumstances than he did. And one way of looking at the two approaches, my way of working within the system and Snowden's way of blowing it up, is to judge it on the basis of results. What kind of results did he achieve? What kind of results did I achieve? Well, if you look at the results of my work, I'm proud of them. I think we did important work in the late Bush and early Obama administrations. A lot of my colleagues at the ACLU were deeply skeptical that I would accomplish anything inside the system. Others were, they were all, for the most part, not all, but some, most of them were supportive of my decision to go inside the government, but all of them were very skeptical. What did we do? Well, I think we can say with some confidence that we put a program of post-9/11 surveillance of domestic data that had begun shortly after 9/11 in great secrecy and without any real legal safeguards under a presidential power theory, an Article 2 theory of surveillance. And we helped the process of putting that under the secret court, the Foreign Intelligence Surveillance Court, and thereby putting it under a statute, putting in place some rules and protections enforced by the Foreign Intelligence Surveillance Court. I'll talk a little bit more about that program of domestic data in a little bit. So that was an important achievement. We made some significant improvements in oversight to that and other programs to make this oversight more transparent, more effective. But it's fair to say that we missed the broader impact of mass surveillance on privacy. What I was looking at primarily, even though we did have a policy function in my job at the Office of the Director of National Intelligence, what we were looking at primarily was how do we take these programs of mass surveillance and make sure that they are following the existing state of the law. And the reality is the law had not caught up with major developments in technology and society which impacted the way in which these programs affected all of us. In other words, we just sort of missed the boat when it came to the impact of these programs on privacy. So what were Snowden's achievements? Well, we had a revolution in transparency. And by that, I don't mean just that because Snowden leaked documents, we found out about them. That's sort of tautological. What I mean is that the government did something actually quite rare in a situation like this, and that is that it took some responsibility for trying to put those leaks in perspective through a series of authorized disclosures. And I talk about that in some detail in the book. Disclosures of how these programs worked in order to defend and put into context the programs. And let me give you an example. Snowden would put out a document that says Verizon Communications has collected all of the phone records in the United States under this order from the Foreign Intelligence Surveillance Court, the FISA Court. Correct. But that document doesn't explain, in the way that a series of FISA Court documents did, how that program worked and what the protections were that we put in place for it. So you have kind of two responses when there's a leak from Snowden. One response is to clam up. Say, I don't know about this program. We're not going to comment on it. We don't want to upset Verizon. We wouldn't say that out loud. we don't comment on intelligence programs. That would be the standard response from a leak. Or you could give a very minimal response of something like, there are certain aspects that we can talk about, but in general, you go away. Or you could do what the government did do in the Obama administration, and that is to declassify the existence of the program, to declassify large amounts of documents about how the program works, to declassify information about where the government made mistakes and what was done about them, and continue to get criticism for all of these things over a series of weeks and months, but with the understanding that now we're having a legitimate and genuine debate about what actually happened, instead of a one-sided argument. There was an end to that particular program I've been talking about, the bulk collection of telephone records, what's called bulk collection. And that's because after a period of approximately 2 years, between 2013 and 2015, after much debate in the Congress, much debate in the law reviews and other places, it turned out that that program was not nearly as effective as the government said it was. This came as a surprise to many people, including me, who'd worked on the program, because scrutiny of that program made it clear that it just wasn't as necessary as we had been led to believe. When you're talking to yourself in a secret room somewhere, you can convince yourself of a lot of things that you can't if you expose the light of day. So that program came to an end as a result of a combination of legal challenges and ultimately a decision by Congress to reform how it worked. There were reforms to the Foreign Intelligence Surveillance Court, the FISA Court. Probably the most significant of those reforms was to include a public advocate, a special advocate, in selected proceedings of the court as a regular aspect of the court's functioning. The court had on a couple minor occasions before the participation of outside lawyers, but in the past they had only heard from government lawyers. So this was a major reform. And what I think is the most significant reform, and I'm one of the only people who thinks this, but I really do think one of the most significant reforms that was the result of Snowden's leaks were new rules for the privacy of foreign citizens outside the United States. These are people who, under Supreme Court precedent, do not have rights under the Fourth Amendment to the U.S. Constitution, and in the past had been essentially ignored in terms of the way the government would worry about protections for data. People with outside the country, their privacy didn't count. It didn't matter. When I was in the government, I would tell people, what do you do? I work for privacy. I work on privacy issues for the intelligence community, and I get a lot of, that's interesting, and that's being a fox in the hen house. I thought it was more like being a hen in the fox house, but and then they would say, well, so you're worried about domestic surveillance. You're worried about spying on Americans. And I would sort of nod and say, yeah, that's what I'm worried about, because that was the way we conceptualized privacy up until 2014, actually, when these rules were put in place as a result of the Snowden revelations. So I think it's actually clear that the verdict is out, and Snowden was more effective than I was. And so part of the reason I wanted to write the book was to ask the question of, can we do better? Can we have our cake and eat it too? Do we have to be condemned to this system where we have a period of introspection about privacy and surveillance every 2 or 3 decades as the result of a major surveillance scandal, and then we take that opportunity to hopefully make some reforms, but only because of some brave whistleblower or someone who leaks massive amounts of documents with potential serious damage to national security. And to be clear, I think there was quite serious damage to national security. Well, I wouldn't say that. That's going too far. I would say there was certainly potential for damage in the leaked documents that Snowden made available through reporters, and that in some cases there was obviously some damage. And this is a risky thing to do with our secrets. So could we set up a system that is better at overseeing the intelligence community and at self-correcting? And that's really what I wanted to talk about. To do that, I'm going to step back a little bit and again bring you through my journey into the intelligence community and what I learned from it. In October of 2001, I was an ACLU lawyer. 9/11 had happened, the month before, and we were fighting the USA Patriot Act, the Bush administration's anti-terrorism legislation that was brought forward in October of that year. We've been fighting it with very little sleep over the past few weeks. My first son was born actually 2 weeks after 9/11, so I really had no sleep for, it feels like, several years. On the floor, on the steps of the Capitol, we were handing out pieces of paper to members as they went to vote, urging them to slow down and to look at the kinds of powers that they were voting to give the government. Now, one of the things that they were doing in that law was to expand the ability of the government to get records in terrorism investigations. This is the famous Section 215 of the Patriot Act. That section became known over the next few years as the Library Records Section. It says absolutely nothing about libraries. It was never used, we believe, ever to obtain anyone's library borrowing records. Why was it called the Library Records Section? Well, it's our fault. That's the ACLU's fault. And the reason is because as we were thinking about ways to make the point that these provisions could be misused by the government, we pointed to the very low standard that was in the law, just relevant to a investigation, a very, very low standard, and not a criminal type investigation where the investigation is bounded by the criminal law, but by a new kind of investigation, the foreign intelligence investigation, which is bounded not by the criminal code, but just by what is a threat to the country. No need to show any connection to a foreign power, agent of a foreign power. And we thought this was potentially dangerous, and we looked back at potential examples of historical abuses, and we had worked with the Librarian Association in the past, and this was one of many groups, actually, that the ACLU worked with in the aftermath of 9/11 to raise awareness of the potential for misuse of these new surveillance powers. And so as part of that campaign, the librarians worked together with us to put up posters that said, under the USA Patriot Act, your library records could be demanded by federal agents, and we would have no right to tell you that that had happened. Absolutely true statement, because that was true of any record, anywhere in the country. We were accused by Attorney General John Ashcroft of trying to scare peace-loving people with phantoms of lost liberty. And I have to say that in retrospect, he was right. He made a point. We were trying to get people energized around their civil liberties, and we didn't know how the government was using its powers. We were essentially fighting phantoms. We were shadow boxing because the government wouldn't make available to us at the ACLU or the general public how it was using these powers. In 2006, I had a unique opportunity to go inside the surveillance state. The government had just completed, or just was beginning, its massive reorganization of the intelligence community by creating a new head of the intelligence community called the Office of the Director of National Intelligence. That's currently Dan Coates. There have been, I think, 5 directors since I joined. I served under 4 of them because they kept coming and going. Anyway, this office contained in it something that I helped put in it as an ACLU lawyer, which was an Office of Civil Liberties and Privacy, which was kind of our little victory. We kept losing over and over and over again after 9/11. This was our one victory. And in talking with some of my colleagues during that debate, they suggested to me, hey, we might like to, you should go work for them. And I thought that was kind of crazy. I said, you do realize that we're talking about President Bush and, the ODNI. I got an interview to meet with the head of the office. It turned out he was not just the head, but the only employee. I was the second. I turned out to be the second employee. It was a surreal moment going through the old CIA headquarters where they were still located. They moved a couple times. And that was the same day that we learned about a Bush surveillance program to undermine and circumvent the FISA Court, which became known as the President's Surveillance Program. It was part of a broader program that was still very secret called Stellar Wind. When I got into the government, I learned about what that program was and did, about the whole way in which the NSA worked after 9/11, very, very aggressively. Michael Hayden, who was the director of the CIA, he'd been director of NSA, talked about how after 9/11 the intelligence community needed to have chalk on their cleats, meaning we need to be coming so close to the line of what's legal that we're touching it. And that certainly was the approach that I saw. And it turned out that in the early 21st century, that approach leads to a lot of data being collected. And this is why. Something that was described in classified testimony at the time, since declassified, as the Homefield Advantage that the NSA has. And this graphically illustrates it. This is a picture of the fiber optic cable network around the world by bandwidth. And as you can see, the global internet is connected through the United States. It's a little bit counterintuitive, which is why I always put this up here. It's not just that the United States has a lot of internet companies. It actually has a lot of the infrastructure that makes the internet work. So if you are sending an email in the early 2000s, you have your Yahoo Mail account and you're a suspected terrorist in Yemen and you're trying to communicate with compatriots in Pakistan, there's actually a pretty decent chance that your email will travel through the United States. Not very intuitive, but accurate. So all sorts of data, both internet and telephone, is traversing it. And this is the result of a change in technology that had taken place starting really in the early to mid 1990s. So in the course of reviewing these programs and understanding them, we took some of those domestic programs, we reformed them to some degree, put them under the control of the secret court. Many other programs remained outside the court. We can get into, I can give you excruciating detail about exactly what type of data requires a FISA court order, but I would actually refer you to the book. I wrote that chapter about 5 times to try to make it as simple as possible, and people still tell me it's the hardest part of the book. It's the necessary part of the book if you really want to understand how this kind of thing works. It has to do with where do you gather the data and who are you looking at. If you gather the data outside the country and you're looking at somebody who is not a US resident or citizen, but you might encounter people that they're talking to who are US residents or citizens, you don't need a FISA court order. If you're doing the exact same thing, but you're gathering the data inside the United States, you do. It's arbitrary, it's technology dependent, it doesn't make a whole lot of common sense, but that's the way the law works. So we tried to take these programs and adapt them in ways that made some kind of sense. So in 2008, I was in the government, and then Senator Obama was mounting his historic campaign to become president. And in the course of that campaign, he made several promises about a new approach to the war on terror, saying that he thought that the Bush administration had gone too far in the direction of unilateral presidential power, that in order to have an approach that would be effective, there needed to be a shared responsibility among the 3 branches of government, and that as part of that, he would review all of these NSA surveillance programs, including programs that had leaked and had caused a great deal of controversy because they were not reviewed by the FISA court when it appears that they should have been. However, during the course of that campaign in the summer of 2008, Obama flip-flopped on a very important issue, which was called the FISA Amendments Act, which basically made it easier for the government to continue their mass surveillance programs with approval from the FISA Court. Obama had voted against it in the previous year, but during the primary. But now that it was the general election, he flip-flopped and voted for it. A lot of his supporters were very angry about that. And he wrote an explanation for his change of mind. And he could have just said, well, come on, guys, I won the primary, and now we're talking. That's not what he said. And I don't actually think that was the main motivator, although, you know, politicians are politicians. He said that he thought that the bill had improved and that his objection to surveillance had always been about unilateral presidential power. And this should have been a signal to people. It should have been a signal to people that Obama, the constitutional law professor, and you know, as famously in Chicago, would have you know, a different legal approach to how surveillance works, but that the bottom line might be the same. Important part of this is that the debate in 2008 over surveillance was really not a complete debate. Some of the surveillance of foreign telephone calls that was taking place had become public, but these massive bulk collection programs of what's called metadata were still highly secret. What is metadata? Metadata is the routing information for a communication. So for phone calls, that's the phone number dialed and dialed, as if we use dials anymore. All of our language is analog, by the way, to describe digital communications. The telephone number, the identifying number, when the call took place, how long the call was, but not the content of the call. Well, you can, of course, tell a great deal from metadata, and in fact, in some ways, metadata, when aggregated and accumulated in bulk and put together in a call graph, can be far more revealing sometimes than content. But the Supreme Court had ruled that metadata was not constitutionally protected and content was. As a result, metadata was being collected in bulk by the NSA, but this was still secret in 2008. I'll tell you a little bit about my old boss, General Clapper, who almost lost his job over these words that he gave in early 2013. So we're pushing forward about 5 years into the Obama administration. He's been reelected. I've been at the White House for some of that time. I had gone back to the ODNI, and now I was already up at Brown when this happened. And essentially, what had happened is that when it came to this metadata program of bulk collection, meaning the collection of all of the data from the telephone companies, it was not public, but it had been briefed to the right committees in Congress, including the Senate Intelligence Committee. And on the Senate Intelligence Committee, one senator who's a very strong privacy advocate, Ron Wyden, was deeply upset about what he viewed was the misuse of authority under the Patriot Act, that library records provision I told you about, to collect all this metadata. That was the law that was being used to amass that data. But he couldn't get the attention of any of his colleagues, and he felt bound not to reveal the existence of the program because it was a highly classified program. So he laid a tough question, what you might even say a trap, except that it's not a trap, for reasons that I will tell you next, to General Clapper. And it had to do with statements that the intelligence officials, including the head of the NSA, had been making about how we don't collect all your data. That's exaggerated. So he put Clapper on the spot. And he asked him, does the NSA collect any kind of records at all on millions or hundreds of millions of Americans? Asked him this question in public testimony, in the hearing on intelligence that takes place on an annual basis. And this was Clapper's answer. No, sir, not wittingly. Now, this answer, let's just be very clear about that. This answer is obviously false. There have been many explanations that General Clapper has given for why he gave this answer. some convincing, some less convincing. I analyzed this in the book by pointing out the clash of duties that this presents for Clapper. Clapper, of course, is under oath, so he has a duty to tell the truth and the whole truth. Except he also has a duty to not tell the truth and to certainly not tell the whole truth, because he is responsible by law for protecting intelligence community sources and methods. And this was regarded as a source and method of intelligence collection, highly classified one. Now, of course, he could have evaded that clash of responsibilities by telling Wyden, I can neither confirm nor deny that the government collects hundreds of millions of records of Americans. We can discuss it further in closed session. I think, you know, that would have been a yes. Yeah. So I still think it was a big mistake. If you know, hindsight is 20/20. If I had been the general counsel at the time, and if they'd asked my opinion, I would have said, just to be clear and fair to Ron Wyden here, Ron Wyden did not just spring this on Clapper at the hearing. He had given him notice, 1 day's notice, said, I'm going to ask you this question tomorrow morning. If I were Clapper's lawyer, I would have said, you can't appear at that hearing. That would have been my answer. You need to cancel your appearance, and you need to talk to Senator Wyden immediately on the phone and explain this. He didn't do that. Later, Snowden said that part of the reason he decided to leak all the documents he did is because of this, this lie by Clapper under oath. Others who are less sympathetic to Snowden question that. They say, well, he'd been planning this for many months before then. We don't really know what was in Snowden's mind at the time that he did that. The point is that all of this came to a head just a few months later. This testimony was in March of 2013. In June of 2013, along comes Edward Snowden, and we learn that, you know, Obama's slogan seems to have changed. We start to see posters like this. Snowden revealed a lot more than just the bulk collection of all of the telephone records in the country. He also revealed very significant programs of internet surveillance, which were using authority that Obama had voted for in that FISA Amendments Act in 2008, but in ways that people hadn't fully anticipated or understood. The names of the programs being Upstream Collection and PRISM. If you're really interested, I can explain to you the difference between those two. But you'll be able to get into my Wi-Fi, which is named Upstream Collection, if you read my book. Because what's the key to Upstream Collection? FISA Section 702. And many other NSA programs outside of the purview of Congress or of the FISA Court involving the breaking and undermining of the security of communications worldwide. Now, in some ways, none of these should have been the domestic bulk collection was a legitimate surprise because it involved the interpretation of a law that was actually quite surprising to most people who hadn't been part of the debate as I had been. The internet surveillance should have been less surprising because it's a fairly straightforward interpretation of the law, but again, quite vivid if you haven't, if you didn't know about how these programs worked. The last ones, which were in some ways the most controversial, were in some ways should have been the least surprising because what is the NSA's job? It's to break into communications. What I think people didn't recognize is the way in which that job, as it started in World War II and continued through the Cold War, had affected in much more dramatic ways the privacy of everyone around the world in the internet age. That there was not a clean distinction between foreign and domestic, there was not a clean distinction between government and commercial and private communications, and so this was affecting all of us in a way that arguably, at least, the NSA had not done in earlier periods of our history. So what was the response of the Obama administration to these revelations? Well, one of them, as I've discussed, is a major transparency drive, thousands of pages of documents. One thing I talk about in the book, which is I think just a striking fact, is that just the sheer volume of documents about top secret intelligence communications program that were released, officially by the Obama administration in this period was more than double that of the number of documents that were leaked by Snowden. So maybe we should be calling them the Obama revelations or the Clapper revelations. But they helped to put into perspective the revelations that we got from the Snowden leaks. And that continued with an annual intelligence transparency report, something like, this has been something of a trend. We've seen transparency reports not just from the government, but also from Google and Verizon and other tech companies have put out transparency reports about what kind of data is being requested by governments around the world and how they respond to those requests. And now we have a transparency report from the government itself explaining some of its programs and how many targets are being affected by these programs. We also get a reform of the bulk collection of intelligence of telephone records under what's called the USA Freedom Act. This is not actually the official NSA seal. I should caveat that. This is the Electronic Frontier Foundation's take on the NSA seal. I actually think it may not do exactly what civil liberties advocates would hope, which is to scare people about the big bad Big Brother. I actually think it kind of makes them look kind of cool. But here we go. In reviewing the value of the bulk collection of telephone records, the government had made statements about terrorist incidents or attacks thwarted by certain intelligence programs, and this was one of them. They said, we've stopped 50-odd intelligence potential terrorist attacks and plots over the past decade or so. Among them have been 13 affecting the United States, and this was a big part of it. It turns out that those figures were, there was less to meet the eye when it came to the bulk collection of metadata. And that's because of an investigation by an outside privacy board inside the government but outside the intelligence community called the Privacy and Civil Liberties Oversight Board. I have to say that I myself was surprised at this finding because I had worked on these programs, and it was the case that certainly the government had used intelligence in the way it described. What the privacy board did, which was an enormous service to all of us, to the public, was to look deeper at each of those incidents than I had, and to find out that not only, yes, the government had used this program in those particular cases, but they could and actually had obtained the data elsewhere without having to assemble this mass database. As a result of that finding, probably the most important result, Congress ended that program in 2015 when it came up for renewal with the Freedom Act. Initial reports from that were that the NSA actually may have gotten more benefit out of the new system. The new system allowed them to collect metadata, but not all in bulk. Not to get all the metadata and then sort through it themselves. Instead, they would go provider by provider and get metadata as well as metadata linked to it out to 2 hops, which is a substantial amount of metadata, but not all of it. And that by using this new system, the NSA, within 6 months or a year or so of that system having been put in place, the NSA General Counsel said, we like this. This works for us because we actually get access to more relevant data, because under the old system, we could only go to the major providers because it involves so much logistical overhead to be collecting all of their data, whereas now we can go out to many other providers. And so it seemed to be a fantastic success story. It may be that was premature because there have been serious compliance problems that were infecting that data. Basically, they were getting more data than they were entitled to get under the law, and they announced that they had shut down and purged a great deal of the data that they had received under this program. Congress will be looking at these issues this year because the Freedom Act, like the Patriot Act, has an expiration. It has a sunset clause. That sunset expires at the end of this year. And so first, the Intelligence Committee has to decide whether they want to renew it, because there are some reports that maybe they feel like this isn't working as well as they thought and that it's not particularly valuable, in which case they may just let it die. If they do ask for an extension, then Congress will have to decide whether to give it to them. Another significant reform I touched on already was the FISA Court. This is I love this take on a courtroom sketch. That's all you see of the FISA Court. So there's your courtroom sketch of a closed door with a padlock on it because it's a SCIF, a sensitive compartmented information facility. Previously, the FISA Court would only hear lawyers from the government. Under the Freedom Act, under this law in 2015, the Congress included a provision that requires that the court appoint a lawyer to argue the other side of cases whenever there is a substantial question or significant question of law. So this was an important reform. And they have also appointed technological experts now. That was a suggestion that I had made and pushed for very strongly, that you shouldn't just have lawyers for the government talking to other lawyers who were making the other arguments, that you needed technical experts that the court could hear from that were independent of the government and not just rely on the NSA's own experts or the other intelligence agencies. And then, as I explained, the sort of most far-reaching reform, in my opinion, was the issuance by President Obama of Presidential Policy Directive 28, PPD 28, which put in place for the very first time in American history and probably the first time in the history of the world, privacy protections in surveillance programs that affect people outside the country. And this document, which is kind of one of these, seems like a fairly bureaucratic document, a presidential policy directive, actually has some inspiring language in it. This is from PPD 28. All persons should be treated with dignity and respect, regardless of their nationality or wherever they might reside, and all persons have legitimate privacy interests in the handling of their personal information. This is a truly revolutionary statement for the American intelligence community. The idea that all persons have legitimate privacy interests in the handling of their personal information. That when we talk about privacy, we don't just mean U.S. citizens, U.S. residents. And I think we are still in the early days of seeing how that directive will affect the overall culture of the intelligence community. The reason that I have a picture of Obama meeting with technology CEOs in December of 2013 is because they were actually very influential in making this happen, and not out of the goodness of their hearts. It's not because Google and Facebook are big proponents of privacy. It's because they were seeing serious potential repercussions from the Snowden revelations to their businesses. If people around the world don't trust American companies because they think that those companies will simply provide mass bulk data to the government, they were going to lose a lot of money to foreign competitors. And so part of the reason for these privacy protections for foreigners was to assure allies around the world that the US government does actually have at least some level of privacy protection that applies across the board and not just to Americans. In the book, when I get to the sort of Paradiso part of the book, part 3, what would I really want to reform mass surveillance, one of the things I talk about are exciting and innovative forms of cryptography that could help us have the benefits of information without such a huge impact on privacy. There are two of my colleagues at Brown, Seni Kamara and Anna Lisianskia, who I happen to be married to, who have done extraordinary research in this area. And they allow you to do things that seem magical, that seem like that you can't do. And I think policymakers need to be more aware of these. Seni Kamara's work is in encrypted search, and he's written about reforming the NSA's bulk data collection programs in a way that would allow them to retrieve from that bulk data set only the information that they are looking for, to pose a query to a bulk data set in encrypted form, where that bulk data set is also encrypted in a way that the government doesn't have access to the key. But they can still pose an authorized query, and then if the query has a return that we've decided as a society is the kind of thing that we do want them to be allowed to have, they would get that result in a reliable way, in a secure way. In other words, instead of trusting the government to have access to these kinds of bulk data sets based on people like me, privacy overseers, you wouldn't have to trust the lawyers. You could just trust the math of how these programs worked. Professor Lysyanskia has done work in anonymous credentials and zero-knowledge proofs. These allow you to present your credential in a way that reveals, in a digital environment, you can present information that shows that you are authorized to receive somebody's information without having to reveal your own identity. This could be enormously valuable in figuring out ways of improving the way in which the government interacts with private sector entities in a way that gives the private sector entities some assurance that their data sets aren't being rifled through willy-nilly. So these are great techniques that could help improve the way we handle this issue, that would allow us to have our cake and eat it too. I want to close with some thoughts on Trump. And I have two quotes to illustrate, what I think the impact of Trump might be on this whole issue of mass surveillance. So far, we've seen a fair amount of continuity on some of the reforms that Obama put in place, which is a little bit surprising. PPD 28 survives, and we see some of the same policies from the intelligence community. In the beginning, my sense was that Trump was going to have, we were going to be in a sort of post-9/11 world plus with Trump. Famously, or maybe not so famously, he endorsed warrantless surveillance in a campaign rally, saying that I want surveillance, to cheering crowds. This sort of seemed like the return of a kind of authoritarian style. I mean, it certainly has an authoritarian style, but also the return of a presidential power argument. To protect the country, I need to be able to suspend certain civil liberties, and that means in the case of a terrorist attack, we might have to go back to the kind of warrantless surveillance that we had in the early Bush years, and maybe worse. But fairly quickly, even before he took office, but especially afterwards, in 2017 and 2018, we got the witch hunt narrative. Terrible. Just found out Obama had my wires tapped in Trump Tower. So instead of Trump as the authoritarian strongman who is pushing for surveillance, we seem to have ended up with a Trump who sees himself as a victim of a deep state, using all of its nefarious surveillance powers against him. In a course that I've taught that covers some of these issues, at one point I had this wonderful 5-minute video of Sean Spicer trying to defend this tweet by going through 10 or so different surveillance powers that the government had in a kind of, ACLU advocate way. Saying, look, the government they can get this data from the British, and the British don't have to follow our rules, and the government can get metadata, and they don't need to follow rules with metadata, and Obama lifted these restrictions on this and that, and I kind of felt like, well, this is kind of bizarre to have the president's spokesman kind of going through all of the loopholes in surveillance law and how terrible they are. we have not seen any of that skepticism of the deep state translated into any actual reform of surveillance in the deep state. So, you know, it seems to be entirely rhetorical. But, you know, I think these are the two sides that I see of Trump, and we still have, you know, a ways to go to see what his legacy is going to be on the issues of surveillance. So in conclusion, you know, my advice about how to reform surveillance for the next administration would be more transparency, to continue and improve upon our PPD 28 laws that respect everyone's privacy, not just those of Americans, and then using the magic of cryptography.
Well, thank you.